Your permission, may I?
Yeah, please.
Thank you, ma'am. Good afternoon, all. Welcome to the next session of International Teaching Month on the theme labor law and on the topic Furlough, labor law's response to the global pandemic. We have today with us Dr. Stephen Hardy, and just a short, brief introduction about Sir. Sir is currently the Dean, Faculty of Business Law, Politics, University of Hull, UK, with over 25 years of vast experience. Prior to this, Professor Stephen served as a professor of employment law and head of school at Coventry University Law School. His expertise is in tube, dismissals, discrimination, trade union litigation, and judicial review. Since 2011, he has been a fee-paid tribunal judge in the Social Entitlement Chamber and was recently assigned to the Employment Tribunal. He is a former general editor of Sweet Maxwell's Encyclopedia on Employment Law. He is currently an executive committee member of the UK Society of Legal Scholars, a convener of the Civil Procedure Doctrinal Study Group of the International Association of Law Schools, and an academic panel member of the Administrative Justice Council. Sir, on behalf of Institute of Law, Nirma University, we welcome you, sir. Before we proceed with this session, I would like to state the protocol for this session. All the students are requested to please switch on their cameras for the session. Please put your microphone on mute mode. And the session, which will be for a duration of 40-45 minutes, will be followed by a question answer session. Please send your questions to me privately through the chat box. And now I would like to invite Professor Stephen Hardy, sir, to take over the session and deliver his thoughts and insights on the said theme. Over to you, sir.
Well, first of all, namaste, and thank you for your warm welcome as ever, and thank you for your kind invitation to join you. Some of you already know that only a year ago, I was with you in Nirma discussing with colleagues and students the legal issues of the day. At that time, there was talk of a pandemic in Wuhan in China. At that time, no one would have thought that we would find ourselves in the devastation and the system of which we now do. So I think as we celebrate law, life and diversity today, and you are doing throughout your month, which is laudable and commendable as a law school, and I congratulate Madam Dean for producing this momentous project in very difficult times. But I think in celebrating law, life and diversity, I think the last 12 months has shown how important law can be, how important life is, and also diversity and exchange and sharing of information is critical to dealing with today's global problems. So that's why, as the labour lawyer, the humble labour lawyer, I've come up with the topic that I've chosen today. Because as each and every one of us comes to terms with the consequences of COVID, each and every one of us is also approaching it from a different perspective. Obviously, we're dealing with it as individuals. Obviously, we're dealing with it as families. And more importantly, we're obviously dealing with it as countries and governments, but also we're dealing with it as universities and scholars. So as a scholar, my contribution and reflection during this terrible time has been, what is my discipline's response to the global pandemic? So that's why I've chosen furlough as my particular topic. Now, I think it's particularly pertinent to raise at this point that in terms of the global pandemic, the World Health Organization that guides us all sadly reports there has been 2.1 million deaths. Also, there is ongoing 100 million cases of COVID across the globe. That, as you will see, is a terrible situation. And I think more to the point, it emphasizes the scale. So whilst I bring you warm greetings from my own university and you exchange your greetings, you will see that in terms of the World Health Organization, the picture is bleak. So if we could move on a few more slides, and Richard, that'd be great. Thank you. So this is a bit about our university. So again, click. I'm sure you can all have a look at this later. I am in the world. If you take me to the next one, and the next one again. So there we have the bleak picture. Now, what this bleak picture doesn't tell us, and it's not for the World Health Organization to tell us, of course, is how our government's responding to that bleak picture. And so when, as we today celebrate law, life and diversity, I thought in terms of diversity, I would share with you how some countries, including your own and my own, have dealt with this situation. Now, as I said, next please. As I said, that in terms of where we are, COVID has created chaos. And chaos on a scale that we've never seen before. All of you as students will know that remote education was something that we've often dreamed of in universities, never dreamt that we would produce, but we have in a short period of time. And it works. The blended approach of some face-to-face with online is a long established method, but actually just doing remote brings its different challenges. But of course, today celebrates that achievement that from across the globe, we are able to connect to each other and continue our education. Again, that's credit to your institution, NERMA, and my own university and many universities across the world who are adapting to this change. So next slide, please. And in this chaos, because COVID has created global chaos, the biggest impact has been on global economies. And you might have expected that a Labour lawyer is going to talk about the political situation, the legal situation, the social situation, but also the economic situation. And the COVID chaos, as you all know, has disrupted. It's a disruptor. It has disrupted our health services, our travel, our education, our supply chain, our productivity and production, but also our governance. And if we just take those 6 consequences that impact as factors upon any economy, it is plain from that list that there are legal consequences for each of them. There are travel restrictions that has human rights implications. Our health services have been disrupted, so there is an issue of access and privacy and dignity. Our education is disrupted. There's an issue of contracts and risks and liabilities. Our supply chains mean that we are in breach of certain requirements, but our productivity means that that is less, and therefore that impacts upon everything. It impacts upon the production and the manufacture of PPE equipment. It means that less vehicles are mobilized. It means that our education is less than it might have been in terms of provision. But all of those things come down to governance. And so in this time of crisis across the globe, a global pandemic, our governments are under scrutiny more than they ever have been. And whether it's the Indian government, the United Kingdom government, or any other world government, there is a questioning by the people of how are you protecting our health, our travel, our education, our supply chain, our productivity, our economy, but also are you conducting yourself in a legal and fair way? And that's where I enter this debate as the Labour lawyer, because any lawyer who is listening to this will understand that there are legal issues behind this pandemic. Now, I'm not suggesting for a moment that we should put law first in a pandemic. Individuals' health and life comes first. Because we know in this pandemic, the alternative is death, the end of life. But what I am suggesting is the lawyer can contribute to this debate to ensure that during these times of emergency crisis, we do have health services, we have travel where necessary, we have education, we have a supply chain that works, we continue our production, we save our economy, but at the same time, we ensure that we are offering this in a fair, consistent, and coherent manner, what we call the Bangalore principles in terms of good governance. So whilst I've now excited constitutional lawyers and I've excited contract lawyers and tort lawyers and healthcare lawyers, all sorts of lawyers, I now want to retreat to labour law's response to this pandemic. So moving to the next slide, you will see that we introduce the concept of furlough, the world of work. The world of work has been obviously affected by the COVID crisis. There has been lockdowns across the globe. New Zealand, Australia happened for short shy of 4 months. In America, there has been monthly lockdowns. In the United Kingdom, we are in amidst our third national lockdown. In between that, we've had restricted periods. We've had a tiered restriction system in place. But across the globe, like the United Kingdom, we have seen business collapses. In particular, in the United Kingdom, lockdown, restricting individuals going out, has had a huge impact upon the hospitality industry, for restaurants and also other public retail outlets. But the key issue has been a focus and a refocus upon employees' health and well-being. Because whilst we all work from home, a new concept, not necessarily new, some of us have done it before, for part of our time, but not at the scale we are now doing it, that working from home brings a whole new dimension to the employment relationship. So the employment relationship has been affected by COVID in terms of loss of jobs, in terms of restriction, but also in terms of thinking about our health and well-being. For example, and I suspect most observers of this lecture will agree with this point, that when we work from home, we work longer hours. We probably work more intensely, harder, because we're focused upon a screen. And sadly, that has not good benefits for our health, so we are told by the medical profession. So these things are serious considerations for the individual worker, but also the employer. So if I may move to the next slide, please. So in response to these impacts upon the world of work, a new phenomenon has come to the front. That frontline headline phenomenon is known as furlough. Furlough has been readily accepted in the lexicon now as a word that we all understand, although it is an American concept that is not new. Gelman identified as long ago as 8 years ago that if employees temporarily leave their work, they're on furlough. Furlough comes, of course, from the Dutch word, as you see on the slide, which means leave of absence. So the world's response to the pandemic has been to produce temporary leave of employment. Now, let's pause for a moment. This hasn't happened in that manner all over the world, but this is the basic principle that has created the variations we are now going to examine. But the mainstay concept has been, in response to the pandemic, in labour law terms across the globe, you should furlough your workers where possible. In other words, for their own safety and health and well-being, you should give them leave of absence. But that doesn't mean they're not working. It means that they're working from home. So let's now look at this fascinating development that's been readily accepted across the globe. And let's look at the variations of it. So I want to do some comparative evidence here. This is the diversity of your law and life theme for your conference. So moving to the next slide, if I may. First of all, we're going to think about the 50 million workers who are allegedly, I use that word legally and technically, because allegedly they're on furlough. But are they, is my first question, and we'll deal with that as we deal with each country. And secondly, if they are on furlough, what does that mean for those individual workers in that country? Is it the same or is it different? Because, of course, as lawyers, we like to seek commonalities, similarities, but also we like to look at difference. That's what makes us comparative. That's what makes us global lawyers. So moving then to the comparisons, if I may. I'm going to start with my own country, the United Kingdom. You will see the picture of Rishi Sunak, the Chancellor of the Exchequer, who's well known in India due to his very strong relationships with India by marriage. And Rishi Sunak, the MP for Richmond, and not very far from where I now live in the United Kingdom, is the cabinet minister responsible for the response to the pandemic, not just economically because he's Chancellor of the Exchequer, but also in terms of our global economy, our reaction to the global emerging process, but also how we manage businesses and therefore how we manage labour law. Although we do have a business secretary, currently Kwasi Kwarteng. At the time, previously it was Alok Sharma. And as long ago as April of last year, the UK government committed itself to a furlough scheme in the sense of the American phenomenon, where we would provide, the government would provide state aid to individual employees. Now, just for those who have been following closely the UK system, we are now on our third version of the furlough scheme. We had an original scheme, then the original scheme was amended, and then it's now being amended again because it's been extended now until May, June of this coming year. And that scheme covers 80% of your monthly salary up to a maximum of £2,500 per month. Now, what this means behind these very bland statements is the scheme is that the employer will determine which employees should be placed upon furlough, will agree with them that they are to go on furlough, and then those individuals will go on furlough and be paid up to 80% of their salary. In the original scheme, they were also paid up to 100% of their salary because the employers topped the salary up. Because this is a scheme where the employer claims back the money to cover the leave of absence. So in all sense, it is a state aid system, which is what the original American furlough system was. I'll come back to that a little later. But this is a pure furlough scheme because the pure botanical position of the furlough scheme is to compensate employers to enable the jobs of the employees to be retained during the period. This is a job retention scheme. Now, in our coronavirus job retention scheme, the CJRS, as we now call it in the UK, our version of furlough, 9.4 million employees have been placed on furlough. That is a huge number. Now, there are advantages of this, which we will discuss later, and there are disadvantages of this. But the key is that this system has cut across existing British UK labour law, employment law. It ignores the current provisions and creates a parallel scheme. A parallel scheme that is temporary and a parallel scheme that is there to secure jobs, state aid supported during difficult times. We have not seen anything like this since the end of the Second World War, where there was a basic furlough scheme. It wasn't known as furlough then, but it was a salary support scheme that existed for a short period of time. That ceased in the mid to late 40s. It was never seen again until we have a scheme such as this. Now, you might say there is a parallel here between an emergency of war and an emergency of a pandemic. And I will come back to that theme a little later. So there is our UK scheme. Let's move and have a look at some of our European counterparts. Now, what is interesting, of course, is that, and I know that your Madam Dean will be the only person who will laugh at this comment, because she's heard me several times at various international conferences talk about Brexit Island. Britain is now Brexit Island. It happened at the end of December, but it did happen with a deal. There was not a no deal. And our Prime Minister Boris Johnson produced what was called the Trade and Cooperation Agreement of December 2020. What that means is we no longer have access to some of the things that we did have access to previously when we were members of the European Union. And I'll say at this point there is an EU coronavirus support scheme where the EU provided 40 billion funds available to members of the European Union. And of course, many members of the European Union have used that money to produce their own and to support their own furlough schemes. France, of course, is no exception to that. President Macron immediately determined that there would be state aid to workers who were placed on furlough, temporary leave. And as some of you know, as comparative lawyers, the Code du Travail, the French Labour Code, is a strict code which requires trade union agreement on behalf of the workforce in a very liberty manner. And consequently, 70% of wages are covered for those French employees who find themselves placed on furlough. And it's a pure state aid system. Different to a furlough scheme, the government gives the money directly to the individuals and, more to the point, secures 70% of wages. Now, for the acute amongst you, you will have worked out there is a 10% difference between the UK system and the French system already. So which is more generous and what does that mean? We'll come back to that. So that is the French system. If we now move to another European system, the German system has a civil code, and its labour law is covered in 7 specific books governing the labour relationship. Similar to a French code, but this is a civil procedure. And so German law, Chancellor Merkel, Angela Merkel, had to produce a special scheme, and their furlough scheme is known as Kurzarbeit. And this means that there is a salary support scheme for German workers placed on furlough, temporary, suspended from their employment. And there's a special process under German law to enable this. But in effect, it yields 67% of wages. Now, again, you might wish to compare that the UK looks rather generous at 80%, the French system at 70%, and 3% less than that is the German scheme. But of course, let us not forget that the German system also has social security benefits, which will support that. Most European systems have social security benefits, social insurance systems that will ensure that the employee is supported to the level of income that they would normally be in receipt of. So the Germans have produced a very sophisticated form of furlough, very much in keeping with their existing German legal provisions. And one thing I would say at this point, just as a point of observation, in my analysis, comparative analysis of these systems, the German system is probably the most protective system and the most secure system that employees could wish for if they found themselves in a furlough situation. So do not be fooled by the figures of the money that is offered. That isn't necessarily just the only indication of the protective system available. And I can illustrate this with the next system, if you would, please. Because I think in terms of importance, the Italian method of furlough is probably the most significant. It wasn't just that a new law was created or a new scheme, as in the UK, was created overnight. In Italy, you'll recall, Italy was severely affected by the pandemic very short after the outbreak in China. And you will recall that certain parts of Italy, well, certain regions of Italy were closed down and there could be no travel between those regions. And the president of Italy issued a presidential decree. This is significant. This is the president of that country determining that this is such an important situation, an emergency situation, that decree is to be made. And the SIGO, which is the salary support scheme, which creates the Italian furlough scheme, does something quite distinctive. First and foremost, it doesn't offer what the figure will be. It says, do not worry, you will work from home, which they call smart working, and you will receive benefits to the exact amount of your salary. Now, one might say that this is probably the best scheme, but the difficulty with this scheme is that you have to claim this scheme. This scheme does not come to you readily as the other schemes might in a furlough scheme. So this is not a pure, this is an impure furlough scheme, because it isn't one that you can readily access. You have to access it yourself. And there are some very, very complex rules in relation to how you go about that. But the basic principle is a protective measure. The basic principle is in keeping with the furlough scheme, but it doesn't give the same state aid approach as the others. It offers greater access to social security benefits existing. So it uses an existing system in a very different way. So I move next then just to my last European roundup for the moment before we look at other countries across the globe. And we move to Spain. Spanish Trabalore is very clear that you claim unemployment benefit and you can only claim it to a certain figure that the state of Spain deems as appropriate for your minimum living standard. And that's 430 euros a month. And immediately Spain was one of the first European countries to announce that should you be laid off from your employment, furloughed, that you would be able to claim unemployment benefit, but you would only be able to claim it to the figure that they deemed as a national minimum. And so it is a protective scheme. It's not one of the best protective schemes, but it's in keeping with the Spanish system and certainly in keeping with the existing framework of Spanish law. And I would say credit to the Spanish labor lawyers that they decided to stick to their Spanish law principles, unlike the rest of Europe, where we've changed our principles and systems to accommodate furlough. They incorporated furlough into their scheme. And that's a very interesting approach, and probably the approach we should all have taken rather than risking what we've done, which I'll come to in a moment. So let's look and cast our eye, just for diversity purposes, across the rest of the world, including India. So let's move to our next slide, please. America. Remember the former president at the bottom of the screen? Yes, he's been out of office for a few weeks. We've already forgotten him. But of course, it was during the period of President Trump that the pandemic hit. And Congress produced 2.2 trillion in terms of a fund to provide unemployment checks, as they're known in the Americas, but we know them as unemployment benefits. Now, what that means is the original furlough scheme that Gelman identified in 2013, which had happened in 2001 and 2002, it took a while for us to recognize furlough, was a scheme by which Congress gave funding for public companies to keep them in business. So it was the US airlines, it was the US car industry. So effectively, the blue collar areas of America were kept going in the early 2000s when they were suffering due to a furlough fund which was created by Congress. And so in keeping with that history, the American Congress produced this 2.2 trillion fund of employment benefits to those who were going to be affected, either lose their jobs or were put on leave of absence during the period. And you will see here, I've given the biggest example so far in America, which is Disney furloughed 45,000 workers, which meant that they all went on unemployment benefits under this fund, under this furlough fund, to ensure that they were still able to live during this period of temporary leave. And of course, Disney, as we know, is still closed for the time being. And until it reopens, they will remain on furlough. So that's the biggest case study there is on furlough globally at the moment. But of course, America was the original furlough fund that we've adapted and changed and modeled, as I've just described before. So let's move now to another example before we move to India. So Australia. Who would have thought that the Australian Parliament would pass the JobKeeper Payment Act, which is effectively a furlough scheme that allows Australians who are affected by furlough, in other words, being put on leave of absence, to claim $1,500 a month. And this is a readily accessible scheme. It's a bit like the British scheme where you apply through Inland Revenue, so your tax system, and your employer claims it, or under the Australian system, you claim it, because there's legislation that allows you to do it. So very much in keeping the common law tradition there with the UK, Australia and the UK system have parallels, except of course that it's interesting how the Australian system sets the maximum figure where the UK sets a higher maximum figure. They're on par, of course, if you do the maths with the different currencies, but it doesn't have a percentage. So again, there's a difference and a similarity that we need to evaluate. So let's move then to India. And this is fascinating. As you will know from your own professors, India doesn't have a furlough scheme. In fact, what has happened during COVID is that Indian employees, Indian workers have found themselves losing their jobs. And of course, that is the consequence of COVID. If you lose your job, what is the safety net? And that is what furlough has produced. One of the positives of furlough is that there is a safety net, because it does give you job security whilst we see what happens. Now, don't get too enthusiastic about that, because of course I'm going to report there is a disadvantage, and I'll come to that in a moment. But as we're focusing on India for the moment, there is no furlough scheme. You are the exception to the rule. But I would remind the Indian scholars who already know this, that the Indian defence regulations have furlough. There is a furlough scheme for the Indian military where they're allowed 20 half days per year off, leave of absence, paid. It's a furlough scheme. But there hasn't been a furlough scheme produced. Now, why is that? Well, essentially, it's not being produced. It's argued by the Indian government because there is a leave without pay scheme. So Indian law will allow you 6 months to 2 years, subject to agreement, for you to have leave without pay. But you will see at the bottom, and just to prove that I do take a great interest in what goes on in India, that the Indian Times has been running now for a few months the story of India Air. Air India wanted to run a furlough scheme, and of course that would have meant that you would have had a furlough scheme in India. But of course that was controversial and not allowed. And so there is some interesting questions here for India as to why you have not had a furlough scheme, why you've had instead maintained that businesses have closes, why has there been no job retention scheme? And I think the answer to that, as we'll see in a moment, is because India has done something that other countries have not, which actually might be preferable in the long term. Although in the short term, this is a very difficult situation for India, and the loss of jobs is always a dreadful situation, as is the loss of life. But I think in the long term, India might be doing something sensible now because of what will come of those of us, including the United Kingdom, who have adopted furlough schemes in the interim. And I'll explain that now. So move to the next slide, please. So if we think about furlough now, doesn't matter what scheme, Australian, American, French, British. What does furlough do as a legal instrument? So this is where the novelty of my study now emerges. No one's done this thus far. No one's looked at furlough as not just a job retention scheme or an economic state aid. No one's looked at it and thought, what does it do as a legal implication? Well, I'll now tell you what it does as a legal implication. It suspends the existing contract of employment. So we've spent many, many hours, many years maybe, creating the employment relationship based on a contractual term, a contractual foundation that overnight we ignore. Now, normally that would be a breach of contract or an unfair dismissal. There would be claims. But we readily accept it, and then we agree to parallel new arrangements. So we have a parallel contract. For example, in the UK system, you cannot be put on furlough unless you agree and you sign a written document to say that you agree, and then you go on leave. And you go on leave and you cannot work for that employer. You will receive your furlough monies, but you can go and work for somebody else. Of course, there's no work available generally, so that doesn't happen. But for some, it might have done. They might have decided to become an Uber Eats driver and make sure that people get their food delivered, for example, in the UK. But what it does as a legal implication is it eradicates the contract or suspends it for the time being in the hope that we do return to that contract. But no one yet has raised or even litigated what happens if we don't. Well, if we move to the next slide, we get to the candid position that I think for once India can sit back and actually praise itself. Furlough as a legal instrument is a temporary measure. It's a measure that undermines the existing contract. So whilst it looks positive and gives job security and hopefully saves businesses, in most cases, it is my opinion that it is purely the waiting room for redundancy. And sadly, in the United Kingdom, we are expecting there to be, over the next few months, when the furlough scheme ends, in excess of 1.5 million redundancies in the United Kingdom. Now, whilst that sounds rather harsh, we have maintained those 1.5 million jobs for over 12 months. So that is one of the positives. And that, of course, is the well-intentions, the good intentions of the British furlough scheme. But sadly, it means that people will eventually lose their jobs. So whereas India has said, if the reality is going to be that we're going to lose these jobs, then it is best that we lose these jobs now and enable these individual workers to move on, and those businesses to close and other businesses to prevail. So I think give credit where credit's due to the Indian system, that the Indian system ethically has decided to be an honest system. Where I have to say, sadly, I do think, and I'm of the opinion, that furlough is a rather dishonest system, because although it is well intended to maintain people employment, it could eventually mean that they lose their employment, and it will be easier for that employment to be lost than it was previously. Now, how can I boldly say this? Well, I can certainly boldly say it in terms of the UK system, because the UK system has an alternative system to furlough called layoff and short-term working, which has not been exercised throughout this pandemic. And as a labour lawyer, I'm curious as to why that is. Well, I think it's because the British government produced a support scheme, a retention scheme, but I also think it's because, in effect, the furlough scheme has meant that it's an alternative to, and so all options are available. But of course, the only one that is funded by the government is the furlough scheme. So it's a preferential alternative scheme. But if you move to the next slide, if you could please. This has all happened because we have treated the pandemic in a legal context as if it is an emergency situation. And of course, it is an emergency situation. So like wartime, to which I referred to earlier, we have taken these measures as emergency measures, emergency legal measures. And so they are there to try and maintain employment, which is a laudable, commendable aim. But at the same time, a job retention scheme should be a job retention scheme that retains the rights of the individuals concerned. And alas, they are weakened in this process by having a parallel contract that suspends the original contract. And so there is a deep concern here that whilst we give protection in one hand, we reduce it in the other. And also, let's not forget, as a legal instrument, this is a state aid system, and state aid cannot last forever. And if we look at the debts of each of the countries which have been incurred through COVID, they are immense. And I'm afraid to say that that will be for the next decade to come, that the cost of COVID will be another global issue that no doubt another global international conference will deal with. The G20 will meet in the UK, either virtually or physically in September, to discuss how they will have strategies to cope with life post-COVID. And of course, these issues will certainly be at the forefront of their minds, I'm sure, particularly in terms of the impact, the positive and negative impact of furlough. But the last point I would like to make, ladies and gentlemen, before I take your questions, is that international standards have been ignored throughout this whole process. There are international standards on minimum wages. There are international standards on minimum working conditions. There are international standards on the dignity of work. And whilst furlough is well intended, it has interesting legal consequences. The first is the complexity of the rules beneath these furlough schemes. Secondly, the fact that each has different motives, different ends. It's either a social security system, or it's a wage state support system, a salary scheme, or a job retention scheme. There is no coherence within the furlough concept that we've all universally readily accepted. And if we move to the next slide, please. And I think that observation I've just made shows that there are political, legal, social, and economic consequences with furlough that we still have yet to examine and scrutinize. And I'm expecting to have a few doctoral students in the future who will be examining these points and dissecting them to see whether furlough is a good or bad thing internationally or otherwise. But for now, my interim provisional conclusion is that furlough is a legal fiction. It temporarily and actually overrides the existing rules, and I think that is a dangerous step. Wearing my legal hat through my legal lens, I think that is a dangerous thing. India's not got down that pathway, and I pay due respect to India for doing that. And also it puts the economy first, which is no bad thing. We need a good economy, a strong economy across the globe. We need good global trade. We need strong global economies. But not to put people first in a crisis is a very difficult thing. Now, I'm sure that Rishi Sunak and the British government would argue with me that they are putting people first by trying to retain their jobs and retain their lifestyles through state aid, through the furlough scheme. But I remind them respectfully that is only temporary. And if it is only temporary, what is the plan after that? And if the plan is that we are so indebted in the furlough process, then our long-term plan looks bleaker than it might have been. And also, it enables individuals to be dismissed more readily than they might have been previously. But these are matters that will be litigated, no doubt. So there will be legal challenges ahead. And I, for one, and I hope you will join me, will observe those with great interest. I think furlough, the labour law contribution to the pandemic, highlights how there is great interaction between politics, law, economics, and social consequences. I think it certainly shows that there is an interaction between what is economic and social. But I think also, for the benefit and the wisdom of this conference and this teaching month, it also demonstrates that there is law interacts with life, and life brings great diversity from which we can all learn. Thank you all very much for listening and your attention, and I hope that something I've said has sparked some thoughts at this dreadful time during this dreadful pandemic. Thank you very much.
Thank you so much, sir. Sir, we have few questions which we would like you to answer. So if I may please, with your due permission, I would like to proceed with the questions. Thank you so much, sir. So the first question is with regard to the situation in UK. So our professor colleague, Surekha Talari ma'am, has asked this question. So Dr. Hardy, do you think that UK chose a wrong time to come out from Brexit, and then they had to deal with the COVID situation alone?
Well, that's a brilliant first question. So I'm worried about the other brilliant questions that are going to come. I've been very plain, as I always am, and your Madam Dean will confirm this, that I am a great European. I am a pro-European. I am disappointed in my own country for wanting to leave Europe. But of course, I am a Democrat, and so I accept that decision. I think it's a sad decision. But with hindsight, and hindsight is a wonderful thing, that if there was one good reason now to have stayed in the European Union. It's that we could stand together in COVID. And I think being in Ireland, although you have supposedly greater control over your destiny, I think what we've learned in the pandemic is working together, yeah, which is what we do at home with NERMA and NERMA does with the rest of the world, that we work together, it makes the world a better place. So I am thinking now that COVID might have been different. Certainly financially, it would have been different. We would have got, although we pay money into Europe, which we can now keep, we would have got benefits from being in Europe. Although, having said that, to be fair to the British government, who have delivered Brexit, we do have a Brexit agreement, which I'm surprised that we got, but we did get that. And also that not being in the European Union hasn't stopped us cooperating on the vaccine, which is very important. And I think that's probably because of our deep friendship with Europe, which I hope will continue. But yes, one might question, was it the wrong time? My personal view, yes, it was the wrong time, but no time would have been a good time.
Thank you so much, sir. Sir, we have next question again from a faculty colleague, Arpit Sharma, sir. And sir has posed this question as to whether the furlough scheme is going to be applicable to piece rate workers or daily wage workers across the globe.
Well, that's another good question. I think my answer is that in the UK system, it's supposed to apply to all workers. But in terms of piece workers across the world, it would depend upon the variant schemes you're in. So our comparative analysis shows that some schemes don't include the self-employed. The British scheme does. Other schemes don't include certain types of worker, so agency workers. That could also exclude piece workers. So I think the answer to the question is depends on the system, but there's certainly the furlough global scheme, if we call it that, the global phenomenon known as furlough, the basic principle of furlough is that all workers on temporary leave should have access. So there should be no reason to exclude. But of course, what I'm surprised we haven't seen is litigation on this issue, that I'm an excluded worker and that is unfair because. Now, we may not have seen that litigation because we're in COVID, and litigation during COVID is difficult. We've seen courts closed. We've seen courts move online. I mean, let's not forget that as lawyers, it isn't just life is restricted, so is the judicial process, so is access to justice. And so maybe we haven't seen these claims yet because people haven't been able to bring them. But I suspect in due course we will see these claims. But the answer to the question is they should not be excluded, but it does depend very much upon the system, as we've looked at in the different typologies of the comparative evidence.
Thank you so much, sir. So we have another question from a faculty colleague, Arpit Sharma, sir. So, sir, as you have already mentioned in one of your slides, that furlough leads to the suspension of the already existing employment contract, and furthermore, it leads to the creation of new employment contract. So, don't you think that will be anti the social security measures which every employment contract does provide to their workers or employees?
That's another another good question, and also a question that could be a whole new research project in itself, because that's why I compared the European systems first, because in the European systems generally, that's the non-UK system. So in France and also Sweden and also Denmark and also the Netherlands, and to some degree Germany, there are very significant sophisticated social insurance systems. And so their interaction with furlough, as you saw in the Spanish scheme, is very restricted because of that, because they already have the safety net, the social security safety net. What I think is not being thought out is exactly the question that's raised. There is no thought about how these will interact and how they will be disentangled. So let me give an example in the UK system, because I know that best. So in the event that furlough ends in May, June or July of this year, if I'm no longer have a job, will I be able to claim unemployment benefit? Depends on the circumstances of my dismissal. If I'm made redundant, yes. If I am dismissed and it's not my fault, yes. But if I'm dismissed and it's my fault, answer no. So there is no consideration that when we end furlough, what then happens? Now, I assume we revert back to the original contract. So that's fine. We go back to the original contract of employment. I assume that is what happens. There will be a reversion. But no one has thought about the consequences for my tax claim, my social security claim. So again, this is uncharted waters we are going to have to deal with. And again, this is Furlough has produced a new scheme without consideration of the consequences. This isn't the first time that's happened. As I've said, during the war, the First World War and the Second World War, in Britain, we adopted all sorts of measures temporarily as emergency measures under emergency powers. And I think that's what's happened here. And it took 20 years, 2 decades after the war, post-war, to unpick some of those problems. And I suspect in answer to this question, that is what is going to happen for the next 2 decades after furlough.
Thank you so much, sir. So we have another question from another faculty colleague, Kunal Kishore, sir. And sir, he has asked this question that when we talk about the furlough situation, so do you think that the pandemic-induced job retention scheme has moved towards the discussion on universal basic income?
Yes, that's a very, very good point. And I think it has. Answer the question, yes. I think now we're all thinking as a globe, what is a minimum living wage? I think that's a good thing. In the UK, we have a national minimum wage and a living wage. Across the world, we have varying standards about, wages. And as I said, there are international Labour Law Organization, ILO standards, and also now World Trade Organization standards. So I think this has done that. That's a positive out of furlough, that we're now thinking, what is the basic minimum wage for a living wage? In other words, what should be a requirement as a minimum standard? Now, some countries won't like that because they won't want to produce that, and also because, of course, if we're going to set those guarantees, then of course, hopefully, we'll bring an end to world poverty. But that will cost a lot of money, and I have to say, one of the worst things I think we're going to see over the next few years, apart from job losses, is actual economic crisis, recession. And I also think, we've been in this before over many decades, since the 1920s to where we are now, over a century ago, that we've come through economic depressions. But I think we'll see it on a global scale, which is interesting, which will mean that, will we borrow more, and where from and who from? So I don't think poverty and dealing with minimum wages is going to be top of the agenda. But maybe this furlough has focused that issue. We shall see.
Thank you so much, sir. So we have few questions from our students as well. So
Good.
one student, Ashutosh V, has asked this question. Dear sir, would the grant received under furlough scheme be counted as taxable income? And if so, then what would such income be taxed in a normal way?
Well, as ever, that's a very wise question from a NERMA student. And the answer is it will be taxable. And I think your question touches on a point I made in terms of there has been no consideration in any of the furlough schemes as to what the impact will be at the end of the furlough period for the taxation, because taxation will be calculated accordingly. So will it be that was treated as income and therefore taxed as normal, or will there be a special taxation rule produced for that circumstance? There has been no consideration of that. I've asked twice the British government, what is the tax consequences? And twice I've been told that you complete your application to Her Majesty's Revenue and Customs, the UK tax scheme, as normal, and they will tell you what the answer is. So I suspect that tells me that they don't know the answer to that question. But maybe I will do this and see what HMRC, the tax, and I think it's going to be very difficult for any taxation scheme to think, oh, well, is there special rules that we should have applied here? And they'll be adding them retrospectively. What we know as lawyers is we don't like doing things in retrospection. So it's a very good question. it should be through the normal taxation scheme. But if we have an emergency system, should we not have an emergency tax scheme? We will see.
Yes.
Thank you so much, sir. So we have one last question which we'll be taking from a student. That is from the student Palak Jain, and she has asked this question. Sir, when we look at the furlough scheme and the layoff scheme, both talks about temporary suspension of the employee or the worker from their place of employment. So does there exist any similarities and differences between both these schemes related to the workers and the employees?
Again, and another wise question from a student that I always find in my whole academic career, you get the best questions from the students, because they make you think about things you hadn't thought about. And this is an example of that. I hadn't thought about that in terms of, I thought about the differences in terms of if you are laid off, you are put on temporary, no work. But layoff doesn't guarantee you an income. It's supposed to, but it may not. If you go on short-term working, you get work, but you don't get as much work, and you only get paid for the work that you do. Whereas on furlough, you don't have to do any work. You can work for somebody else if you can, but you get a minimum salary that you might have got to cover your temporary leave of absence. So if you look at it in those plain terms, obviously the layoff doesn't guarantee money. Short term gives you less money. Furlough gives you a minimum money. So there is a difference there. But I think the problem is that that's all happening in any of those three scenarios on a temporary basis. And also it's happening outside the contract because it is actually not what your contract facilitates, except layoff keeps you on your original contract. Short-term working keeps you on your original contract. It is furlough that takes you outside your original contract and suspends your contract. And of course, as in the UK, if you need 2 years service, continuous employment, to be able to bring a claim for unfair dismissal, temporarily removing from your contract actually exposes you potentially to having no claim for unfair dismissal. So at least layoff and short-term working maintains your right not to be unfairly dismissed. Whereas actually there's an argument, it's arguable, that furlough removes that restriction and enables your dismissal. But that has yet to be tested in the courts. So I look forward to seeing that. But a very good question. There needs to be more analysis, I think, of the three scenarios. And probably the three scenarios across the comparative schemes. But unfortunately, I've not had time, even in lockdown, to do that yet. But I will, or a PhD student will.
Thank you so much, sir. So because we would like to ask you more questions, but as the time goes on, I would take Poovi ma'am's permission to propose the vote of thanks.
Yeah, so thank you, Professor Hardy. It was indeed an intellectually stimulating talk, and you have made a comparative analysis of UK, India, and some of the EU countries. It's amazing to hear you again, and we look forward to your sessions again in the next season of our International Teaching Month. Once again, on behalf of the entire university, we convey our heartfelt thanks and gratitude for sparing your extremely busy. We know that you're keeping extremely busy due to the new assignments and in these different times. So still you could spare some time with us. Thank you so much, Professor Hardy. We are indeed grateful to you.
Thank you so much, ma'am. Thank you so much, sir. And now I would like to invite our student Palak Jain to formally give the vote of thanks on behalf of the entire student fraternity of Institute of Law, Nirma University.
A very good afternoon to one and all. Albert Einstein has rightly said, education is not the learning of facts, but training of mind to think. We at Institute of Law, Nirma University are indeed honored to have amongst us Professor Dr. Stephen Hardy, Dean, Faculty of Business, Law and Politics, University of Hull. I would like to extend my humble gratitude on behalf of the students of ILMU for kindly accepting this invitation and delivering such an insightful lecture. I'm sure this lecture has been an enriching experience for all of us and will definitely help us in developing a better understanding of labor law. I would also like to thank our Dean, Professor Dr. Purvi Pokhriyal, for the conception of International Teaching Month and giving us the exposure to integrate international vision to our academics and further providing a platform for discourse, discussion, and knowledge sharing. Finally, I would like to thank Anubhuti ma'am, Shreya ma'am, Nilsa, and the entire organizing team who ensured the smooth conduct of the event. Thank you.
Thank you all. And thank you for joining us today for this wonderful session and have a good day. Thank you.